As businesses increasingly rely on data to fine-tune their marketing strategies, safeguarding this information has never been more critical. The General Data Protection Regulation, or GDPR, has taken center stage in ensuring data protection, with a sharp focus on individual rights. Among these rights, one stands out distinctly: the right to object to the use of personal data for direct marketing. Direct marketing is a personalized approach where businesses communicate directly with potential customers, targeting them with tailored messages through various channels, be it emails, text messages, or online ads. This method is highly effective, yet it raises significant privacy concerns, as it leverages personal data to influence consumer behavior. The GDPR serves as a robust legal framework to protect personal data. It sets out strict guidelines for how businesses collect, process, and store personal information. A core principle of GDPR is to empower individuals with control over their data, including the right to access, rectify, erase, and, crucially, the right to object, particularly when direct marketing is involved. So, what does the right to object really mean under GDPR? This right allows individuals to challenge the use of their personal data, especially in direct marketing scenarios. Unlike other GDPR rights, this one is absolute. Once an individual objects, the data controller must immediately halt all related processing activities. This emphasizes the importance of respecting individuals' privacy choices in a marketing landscape dominated by targeted campaigns. Article 21 of the GDPR clearly states, where the data subject objects to processing for direct marketing purposes, the personal data shall no longer be processed for such purposes. And, at the first point of communication, individuals must be informed of this right, and it should be presented clearly, separate from other information. This means businesses need to include this right prominently in their privacy policies or notices. The absolute nature of this right sets it apart from other GDPR rights, which might be subject to conditions or exceptions. This absolute status is designed to offer maximum control to individuals over how their personal data is used in marketing. After all, direct marketing can often feel invasive, intruding into personal space. By granting an unequivocal right to object, the GDPR allows individuals to shield themselves from unwanted marketing communications, maintaining their privacy and autonomy. Exercising this right is straightforward. Individuals simply notify the data controller, whether through an email, an online form, or any other means, that they no longer wish to receive marketing communications. Upon receiving this notification, the data controller is required to stop processing the individual's data for direct marketing immediately. They also need to inform any third parties who may have accessed the data for marketing purposes. Consent plays a pivotal role in GDPR, especially when it comes to direct marketing. Before any communication can begin, businesses must obtain explicit consent from the individual. This consent must be specific, informed, and freely given. However, even after providing consent, individuals have the right to withdraw it at any time. Once withdrawn, the right to object is triggered, and all related marketing activities must cease. Now, it's important to note that businesses might sometimes rely on other lawful bases for sending marketing material, such as legitimate interests, particularly in the case of upselling or cross-selling to existing customers. There's also the soft opt-in under the Privacy and Electronic Communication Regulations. But remember, even in these cases, individuals still hold an absolute right to object to the use of their data for marketing purposes. One question we often hear is, can we contact someone to ask why they opted out or to persuade them to change their mind? The answer is no. This right is absolute. If a business fails to comply, it's breaking the law. While you can seek feedback when someone exercises this right, you cannot continue to contact them for marketing purposes afterward. Non-compliance can lead to severe penalties, including hefty fines and damage to your company's reputation. Moreover, ignoring this right erodes customer trust, a critical asset for modern businesses. So, how can businesses ensure they stay on the right side of the law? First, adopt a proactive approach. Implement clear and accessible mechanisms for individuals to object to direct marketing. Train your staff to handle objections appropriately and maintain accurate records of all objections. Transparency is also key. Make sure your marketing practices are clear and offer easy ways for individuals to opt out at any time. Now, you might wonder, should we delete someone's data when they object? Actually, no. The right to object isn't the same as a request for data erasure. Instead, businesses should place the individual's details on a suppression list, which is used to cross-reference your marketing data. This minimizes the risk of accidentally re-adding their data to your marketing lists. In summary, the right to object to direct marketing under GDPR is absolute. Businesses must include this information in their privacy notices, make it easy for individuals to exercise this right, and act swiftly, typically within 1 month. And remember, the right to object is about halting marketing communications, not deleting data. By placing individuals on a suppression list, you ensure compliance while respecting their privacy.